Hello, and thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. We are going to today talk about the National Interest Waiver, and in particular, the National Interest Waiver as it relates to entrepreneurs. So very excited to go through this. We have a lot of clients who are E2 clients who want to move to a green card, and national interest waiver is one category where we regularly do this. A few kind of housekeeping items before we get on with the presentation. So first, if you do have any questions throughout the presentation, you can feel free to enter them into the question and answer box or the chat box, and we will get to all questions. There's time saved at the end for that. Also, this webinar is being recorded, and we will post this on our YouTube channel once the webinar is done. And we regularly post videos of this nature to our YouTube channel, so you can check out National Interest Waiver webinars, but also other webinars on similar or other immigration topics that are posted there. So that's and definitely when you go there, we encourage you to hit the subscribe button so that you do get notification of future webinars. The other thing is that at the end of this webinar, you'll get, in addition to getting a link to where you can find that video, you will also get a National Interest Waiver guide. So the National Interest Waiver guide is something that we will email to you, and it has a comprehensive set of the immigration requirements that we're going to go through today. So without further ado, we will move into the presentation and talk about the National Interest Waiver. So one thing to kind of keep in mind with the National Interest Waiver is that before you can get to the core National Interest Waiver requirements, so I'll kind of describe those as before we even get to the hard part, you have to meet the threshold requirements, because the National Interest Waiver falls under the green card category of EB2. Now, EB2 has two different and distinct elements or parts to it. So one part is a company that wants to sponsor a professional for a green card. So that's under the EB2 category as well. And they, that particular category, there's a requirement that the individual has to go through the labor certification process, where the entity or the company that's sponsoring the person has to prove that they can't find a qualified U.S. person for the role. So that's kind of one part of the EB2 category. Now, the EB2 second category is National Interest Waiver. And what the National Interest Waiver basically says is that we're going to waive that labor certification process. So that's where the name waiver comes. That is what is being waived. Now, but for both of these, whether it's EB2 company sponsoring you for a green card or National Interest Waiver EB2, you have to meet some threshold requirements before you can even consider National Interest Waiver. So the first, there are kind of three ways to meet the threshold requirement. So the first is advanced degree. So advanced degree means master's degree or higher. So this doesn't have to be a degree from the US. It can be from another country, but if it is from another country, we just would need an equivalency. But so, someone who has an MBA, someone who has a master's in another area of study, that's going to work. And then higher, if they have a doctorate or something like that, that is going to work as well. So that's kind of the easiest way, right? Because then we're just going to show the degree. The second is bachelor's degree plus 5 years of progressive work experience. So that for this, we have to document the 5 years of work experience, so get an employment letter or letters from your previous employers that document that, and show also a copy of your bachelor's degree. So now if you don't meet either of those, so let's say that you don't have a bachelor's degree and you don't have a master's degree, so let's say someone just has a high school diploma, you can still qualify under this category if you meet the exceptional ability criteria, and those are listed there. So you have to hit 3 of the 7 items that are listed on the slide here, and you could still qualify under the EB2 category. But keep in mind that, and it's either or, so it's either a master's degree or a bachelor's degree plus 5 or exceptional ability. You don't have to meet all of them. As long as you meet one of them, you qualify. And of course, we would start with the master's or higher, because that's the easiest one to document. And if you have that, we would just we would stop there. And the master's degree or higher, or the bachelor's degree, they should relate to the endeavor that you're actually planning on working. And sometimes that can be quite broad, though. If you're In particular, if you're an entrepreneur, you can usually link so if you were to MBA, or even if you had some masters in economics or marketing or something like that, you can usually link that to the business endeavors. So, but always think of that before you even consider the national interest waiver, that you have to meet those threshold requirements. And we do get a lot of people who set up consultations and they read this thresholding requirement incorrectly, where they think that all they have to do is meet this and then they can apply for national interest waiver. And that's not the case. So we get a lot of people, they look at the 7 criteria and they say, oh, I meet 3 of these, so I'm eligible for national interest waiver. But all you're eligible to do is apply. So now you if you you now move to step 2, and step 2 is the hard part. So step 2 it really requires, and it's based on the national interest waiver requirements are based on a case. The name of the case is Danisar, and the case has 3 requirements. And the first requirement is that you have a proposed endeavor, and that proposed endeavor has substantial merit and national importance. So when we do a national interest waiver case, the very first thing that we do before we even collect any documentation is have a conversation with the client with respect to what is it that they're coming to the United States to do. So what is their endeavor? And, if we say it's an entrepreneur, it could be that I'm coming to the United States to start a company that does X, Y, and Z, that will hire employees and create economic benefit for the United States. So that could be an endeavor for an entrepreneur, right? So that that's what we've defined. And that particular endeavor does have substantial merit and national importance. The government has said that. They've said that in the Danisar case, and they've said that in other documents as well. Now, creating 1 job obviously isn't going to be enough. Creating 2 jobs obviously isn't going to be enough. But we're looking at pretty substantial job creation here to such that it rises to the level of being nationally important, right? So that's something to keep in mind. Now, the second requirement is that you're well positioned to advance the endeavor. Now, this requirement, it sounds maybe easy on the face, but it's very difficult. And it's probably the #1 reason most national interest waivers are denied, because the first part, you can define that really any way that you like. You can define because it's independent of the individual, and you can define the endeavor as, I plan on creating a company that's going to create 1,000 jobs, and that's going to have an economic benefit of X, Y, and Z. So you check the box for point #1. But now when you move to point #2, that you're well positioned to advance the endeavor, it's well positioned to advance the endeavor that you described in point 1. So now it becomes more difficult, because you have to show signs that you actually are able to do that. So signs for an entrepreneur might be that the company is well capitalized. So maybe you have some additional investors. You have a very strong business plan. You may have a company, let's say someone's on an E2 already, the company's already started, and you have a number of different contracts and clients already. It could be that the business that you started is a setup to solve a particular problem that the government finds interesting and valuable, and you may have, let's say, a patent or other intellectual property that is unique, that will show that you are actually well positioned to advance the endeavor. In addition, we're going to show things related to your educational background and your work experience. So that's going to be important in this area as well. But definitely, as I said, it may sound easy on the face, but it can be a difficult prong. So the third prong has to do with as I mentioned earlier, that the EB2 under EB2, the individuals have a kind of 2 ways of qualifying. So the one way of qualifying is that they the company that sponsors them has to prove that they cannot find a qualified U.S. worker. Now, the government has said that that's in their national interest, because they say that they're protecting U.S. jobs. So what this particular prong does, it says that, well, show us on balance that we should waive the labor certification. So often we're going to be pointing to the same things that we have already documented in prong 1. We're going to say it should be waived because it's nationally important. It should be waived because they're addressing a particular problem. It should be waived because this person is exceptional, like they have great work experience. And so we're going to include a number of different things like that. And in particular for entrepreneurs, what we're going to be able to say is that because an entrepreneur is not eligible to sponsor themselves for a green card under the EB2 category, that this particular prong isn't really that applicable. So, and we've taken wording from the Danisar case to be able to, really make that argument. So, and some of these, when we go to slide 2, some of these I spent time talking about, when I went through the 3 prongs, but to touch on a few more things, one of the great things about the Danisar case was that in the past, before Danisar came out, and that was about 2016, in December of 2016, the government would really focus on national importance and substantial merit on a global, nationwide scale. But Danisar made it very clear that the economic benefit can be in a much smaller geographical area. So you could have something that the government feels is important just to a particular state. So you could argue that, let's say that your business is only going to be located in one area, and let's say that area was economically depressed. That is going to be a great argument if your argument is that the benefit, the national interest and substantial merit has to do with job creation. That's going to be a great argument because you're going to be providing jobs in an area where otherwise, finding employment for the people that live there is something that's difficult. The other thing too that I just talked about in prong 3, that when an entrepreneur is self-employed, that they're not eligible for a green card under labor certification. So that's definitely an argument that we make under prong 3. And one of the things that the case does say is that the planned venture doesn't have to be ultimately successful, but more likely than not to succeed. Now, the government does, like as mentioned before, for prong 2, they do really want to see that you are going to be able to advance this. But I think that the reason this is in the case is because when people later go to get citizenship, and let's say that they, they did national interest waiver, and then the business didn't work out, then, we don't want the situation, or they didn't want the situation where someone goes to apply for citizenship after 5 years, and then the government says, hey, well, you did this and it didn't work out, so you didn't obtain your green card in a manner that was proper. So I think that's the reason that they really included that, rather than on the face of it, it looks like, the business doesn't have to be that far along, or maybe they just approve based on a business plan. But for prong 2, it's unlike EB5 and E2, they won't approve just based on a big business plan. They're really looking for substantive evidence that you are going to be able to succeed. And one kind of very, very significant item that they look for that I didn't mention earlier is a track record. So if you are, if you've done this, what you say that you're going to do, if you've done it, for example, in your home country, or you're in the United States and you're already, kind of moving towards that, like let's say on an E2 visa, then that's really what they're looking for in terms of, your ability to show that you are well positioned to advance the endeavor. Now, a few things with respect to timing. Now premium processing is available for national interest waiver petitions. So you can pay the government $2,500 and they will give you a decision in 45 days. Regular processing might be a year, maybe a little longer, depending on, it's just big. There's no time limit. It's just when they get to it, that's when they will provide an answer to you. But during that time, you do have to kind of look at maintaining underlying visa status. One thing you can do, this is a complicated area, but let's kind of talk about it a little bit. So if you have underlying visa status, like let's say you're on a TN or you're on E1 and E2, you can maintain that status and continue to work in the US while, even when the NIW petition has been filed and you're waiting for an answer. Now, one of the things that is beneficial though, let's say your status is running out, then when we file the I-140, you are permitted to file the I-485, so an adjustment of status application concurrently, but only if the category is current. And right now, the category is not current, not current for any country. So that means that there is a wait, so wait to get the green card. So it's important when you're filing the NIW petition to understand that you will have to maintain some underlying status. Probably the wait time now looks like it's going to be upwards of a year at least, and it could increase. It is going to be important to maintain some type of, some type of status, while you were waiting. And then the whole idea of when you're filing for a green card, you have kind of two ways of doing it, either adjusting status in the United States or doing consular processing. To do either of those, the category has to be current. And there are, depending on the person's personal preference, they're going to, or their circumstance, they're going to make the decision whether they consular process or adjust status. Because if you adjust status, you can't leave the country until you have travel authorization, and that travel authorization could take a year. So in some cases, people may opt to do consular processing and use their E2 or other visa to enter, go in and out while they are, while they're waiting. So another, in 2022, there was some updated guidelines for STEM and entrepreneurs, and all really positive. So if you have a STEM degree, so it's science, technology, engineering, or math, then that's going to be, we're going to use that. We're going to put it, in the forefront of your, of your application, to describe that you are, that what you're doing is nationally important if your endeavor relates to your STEM field. And they also, kind of added more documentation and guidance with respect to how entrepreneurs can show that something is nationally important. So if you get government grants or awards, that could show that it's nationally important. Letters from, different people in industry, investors, venture capital, or different government agencies, all of those can show that you show the importance. And then we talked about well positioned, but in the context of entrepreneurs, for example, if you got accepted to a particular incubator, that's going to be something that's going to be very, very positive. And again, if you're getting government grants or media attention, or your company has significant revenue growth, that's going to be something that's going to be very positive with respect to that particular category. So now let's look at, kind of what's included. So, when you're doing the threshold requirements, you're going to be including, pretty basic documentation with respect to what's there. So basic is obviously going to be, if you have a master's degree, you're going to include a copy of the degree. A bachelor's degree, you're going to include a copy of the degree. If the 5 years work experience, you need letters from previous employers describing that work experience, because progressive means that it's getting kind of more responsibility over time. And then if you're using the exceptional ability, then you're going to provide evidence related to 3 of the 7 criteria. So if you're in have memberships, that's going to be your evidence. If you have a bachelor's degree, that's going to be your evidence. So then, you'd look at the 7 criteria and then provide evidence with respect to that. And then when you're looking at the evidence that you provide for the national interest waiver, you're going to go prong by prong, right? So if you're looking at the first prong and you're saying that, this is nationally important, you may turn to newspaper articles, academic research papers, letters from experts that talk about, why this particular thing is important. If government has published documentation related to why something is important, that's going to be very, very useful. If you are relying on job creation, you're going to have a business plan and maybe an economist report that talks about why the creation of all these jobs is useful to the United States, and provide some quantification of that, so that we can include that in the file. We're going to, for prong 2, we're going to include any documentation related to any of those things we talked about. You're in an incubator, that you've done something like this in the past, your degrees, your work experience, if the company is capitalized, documentation related to the clients that you have. So all of that we're going to include in the file to show that you're more likely than not to achieve the endeavor. And then the last slide that we're going to look at here is one that really is a national interest waiver case study. And this is a case study from a case. It was actually an individual who started a small consulting company. And I stress the word, it was a small consulting company. It wasn't contemplated to be large. And it was a case that initially was submitted to USCIS. It was denied, and then the person appealed, and then the appeals court overturned and said that this actually did meet the criteria. So this was an individual who was offering services to vets that returned to the United States to reintegrate back into society. And he showed that this was substantial merit and nationally important by kind of showing there were a number of expert letters that he had that showed that there were newspaper articles. This was an obvious one, right? Obvious that it was nationally important, that in the sense of easy to kind of put your finger on it, but then and easy to get like lots of documentation that talks about it. There's lots of documentation that talks about the issues that vets have when they come back after combat and different things like that. So and there was a lot of evidence with respect to that. Now the person was well positioned because they had some contracts already they had kind of contracts and letters from local government agencies that said that they were going to assist. The company was well capitalized, and given the work that this person had done before, it showed that a track record of providing these types of services to individuals. So that was very beneficial. And then we talked about the fact that the person was self-employed. This particular individual used that to indicate that this particular criteria wasn't that relevant, but also pointed back to some of the criterion 1 and 2. So this was a great example, and it's a case that we often cite to when we are doing cases for entrepreneurs. It's a case we often cite to because it was a case, again, that was denied and was approved, and it was for an entrepreneur. And the reason we like it, an entrepreneur that was doing a small consulting company, right? So this doesn't have to be a company that creates a million jobs. And the other thing to keep in mind is that this particular individual was not claiming that the job creation was the positive, was the nationally important aspect. They were indicating that the services that they were providing were the nationally important aspect. So sometimes we'll include more than one, right? We'll say nationally important because of X and also nationally important because of Y. In this case, the individual selected just one. But these cases are individual, and when we craft these cases, we do utilize a significant amount of strategy to be able to kind of carve out what it is that's going to be important and what an examiner is going to find as important. Excellent. And so that is really everything with the presentation. And I'm just looking here, and I don't see any questions. I know that it's a fairly complicated area. We do, encourage you, if you want us to assess your individual case, to send us, go to our website, and we have an orange button at the top right-hand corner, which allows you to get a consult, set up a consultation, and we could assess your case. And if someone did write to saying they have a question, so they can definitely type that out and we can answer it. Also, as I mentioned before, this presentation is going to be included in or converted into a YouTube video, and will be added to our YouTube channel. So definitely check out the YouTube channel and take a look at any of the this video or other videos that this or any of the other videos that we have on immigration topics. So the person has asked a question: is it true that a person who is in removal proceedings can still apply to this visa? So it's a complicated answer. So to apply for any visa in the United States, you have to file an adjustment of status. Sorry, let me back up. So yes, an individual can file an I-140 petition. So now the showing, do they meet these criteria? But now the issue becomes, can they get the green card? So if someone's in removal proceedings, it likely they have some bar related to getting a green card. So they would have to deal with that particular bar. So, whether it's a waiver or whatever it is, because they couldn't adjust status in the United States. You definitely couldn't stay here and do it, but you may have an option to do something outside of the United States after, some type of waiver is filed if you're eligible for a waiver. And I'd encourage you to set up a consultation with one of our attorneys, John Barrera, if you want to discuss, waiver possibilities in more detail. Excellent. So thank you again. And, as I said, if you have any additional questions or need any your individual case assigned, definitely set up a consultation and we'll be happy to help. And all of the information, the guide, the webinar, how to set up a consultation, that will all be sent to you through email. Thank you again. Take care. Bye-bye.